I'm gonna wrap up the rest of the AP Gov review I've been doing. So I'm gonna do all of Unit 3. I'm gonna talk about the required documents. I'm gonna talk about how I'm gonna put some stuff in Canvas, some documents that'll help kind of sum a lot of this up for you guys. So it's something you can print out as you're taking the exam on Monday. It should be a quick reference to you. That's not to say you shouldn't have this stuff locked down in regards to memory. You really do. Okay, the more you've got to go look at some document, the less chance you have of doing well on this thing. You're not going to teach this stuff to yourself on the day of the test. All right. Okay, civil liberties, civil rights, the Bill of Rights. Not going to talk about that. I'm going to put a document on Canvas that sums up the Constitution for you guys. It'll also sum up the Bill of Rights. So it's going to just simply say, like, the First Amendment, what's in there: Establishment Clause, Free Exercise Clause, free speech, freedom of the press, assemble, peaceably assemble, petition the government, all that. So, I'm not going to talk about necessarily the Bill of Rights right now. Go look at the sheet that I put on Canvas that sums up the Constitution for you guys. All right. The clear and present danger test. This is something that was established by the Supreme Court in the Schenck versus United States case. Okay, so the clear and present danger test basically says speech that incites violence is not constitutionally protected free speech. Significance of that is you're seeing a limitation of free speech. All right, so with some of these court cases, you see an expansion of free speech. You can make that argument with Teeker v. Des Moines. You can make that argument with New York Times versus United States. But in some court cases, we see a limitation of free speech. We see it in Schenck versus United States. You cannot go into a crowded theater and yell bomb or something like that. That is not constitutionally protected free speech. The Establishment Clause is part of the First Amendment. It's the first part of the First Amendment, which says Congress shall make no law establishing a national religion. It connects to a court case as well. That's going to be Engel versus Vitale. Let's talk about that for a second. In Engel versus Vitale, the prayer was voluntary. However, because students had to basically make it known that they were omitting themselves from that prayer is what really kind of makes it unconstitutional. All right. So the fact that this comes from a government agency saying, here's this prayer that students have to recite, and then students that don't want to recite it have to actually showcase the fact that they're not participating. That's where it really kind of crossed the line in regards to the Establishment Clause per the Supreme Court. It's not that prayer is banned in public schools. It's not, right? So if students want to get together and go have prayer before school voluntarily as a group, that's perfectly legal. That's perfectly within their rights. That's the Free Exercise Clause. What Engel versus Vitale is trying to do is trying to affirm that Establishment Clause that says the government can't force a particular religion on people. Okay, 14th Amendment, two parts of the 14th Amendment that are super important, right? The Equal Protection Clause, which says states have to treat people equally. So, right, this is going to extend civil rights in the United States. And then the Due Process Clause of the 14th Amendment, which is going to extend civil liberties in the United States. Because remember, that Due Process Clause is what's going to start that whole Selective Incorporation piece. Okay, the Free Exercise Clause, that's just simply you can worship whatever religion you want. There is some limitation to the Free Exercise Clause. So there was a case called Oregon versus Smiths, where Native Americans out west were using peyote and saying this is how they worshipped their particular religion. If you're breaking the law, you cannot say, well, this is how I worship my religion. Okay, so there are some limitations to the Free Exercise Clause. Selective incorporation, right? Remember, the Bill of Rights did not originally apply to the states. It took that 14th Amendment Due Process Clause in various court cases to extend civil liberties to the states. Some good examples: McDonald versus Chicago. All right, Second Amendment gets incorporated to the states, and that was pretty recent. That's in the last few decades. Gideon versus Wainwright, that Sixth Amendment right to counsel gets extended to the states. So Gideon versus Wainwright is a selective incorporation case. McDonald versus Chicago is a selective incorporation case. Wall of separation, I doubt you see this on the test. Just some lingo to be familiar with. This is referring to the Establishment Clause. It was coined by Thomas Jefferson, and all he's saying is there's a wall of separation between church and state. You've probably heard that term before, separation of church and state. It's just referring to the Establishment Clause, all right? Okay, due process, rights of the accused, exclusionary rule. All right, understand this because a lot of you guys, right, you're like the exclusionary rule part of the Fourth Amendment. Well, the exclusionary rule isn't in the Fourth Amendment. It's something the Supreme Court's kind of pulled out of the Fourth Amendment. So the exclusionary rule just simply says if evidence is used against you illegally, or obtained against you illegally, it cannot be used against you in a court of law. So if the police just arbitrarily come and enter your home, find some illegal activity, but do so without a warrant or without any kind of probable cause, that's where the exclusionary rule is going to come into place. Miranda warnings came out of the Miranda versus Arizona case. And the police basically just have to, at the state level, the police have to notify you of your Fifth and Sixth Amendment rights. Right to privacy. All right, so a lot of you guys, with one of those FRQs we just recently had, you said, the right to privacy in the Bill of Rights. You're a little bit on thin ice if you start to argue that there's a right to privacy in the Bill of Rights because those words never show up in the Bill of Rights. The Supreme Court has ruled that there is a right to privacy in the Bill of Rights, but that is something they have argued is there. It's not something we just simply see in the language of the Bill of Rights. Okay, understand that an important court case, Roe v. Wade, rests on this idea of right to privacy. Where do we see right to privacy? Third Amendment, soldiers can't be quartered in your homes. Fourth Amendment, searches and seizure. The Fifth Amendment, where the federal government can't take your property without giving you just compensation. And you could say the Ninth Amendment as well, where it just simply says just because you have all of these rights we've listed doesn't mean you don't have others. All right. Okay, jumping down here to civil rights, affirmative action. The federal government and universities have taken steps to ensure that they have more minority representation on their campuses and for federal contracts. Affirmative action has not been ruled illegal. It has been challenged, and all the Supreme Court has said is you can't have a quota system when it comes to colleges, but you can put emphasis on getting more diverse students at your university. All right, Civil Rights Act of 64, it's been upheld by the Commerce Clause. This is basically, trying to ban segregation in public places. That's really the key thing. Piece 2 that was added later to the Civil Rights Act of 64 is Title IX, which basically says to colleges, you're receiving federal money, therefore you have to offer some of the things that you're offering to males, you have to offer to females. Okay, so if you're going to offer male sports, extracurricular activities, and use federal money doing that, you have to offer females the same. Equal Protection Clause, right? Again, a part of that 14th Amendment just simply says that states have to treat people equally. It's been used to extend civil rights, right? Where's the Equal Protection Clause come into place in regards to our court cases? Brown versus Board of Education rests on that Equal Protection Clause, all right? Let's see here. The Equal Rights Amendment was approved at the federal level, but it never received that ratification at the state level. It was basically going to say that the federal government and states have to treat the genders equally. This would have been beneficial in ensuring things like equal pay in the workforce. Okay. Grandfather clause. This was just a way of getting around those literacy tests and poll taxes that existed in the Jim Crow South. This was to enable poor illiterate whites to be able to vote, but still prevent the African American vote through those literacy tests and poll taxes. Strict scrutiny just simply says that if there's any law out there that it's a judicial idea, and it's really kind of the highest form of judicial review. If there's any law out there that classifies people based on race, so you're basically saying that your law is not colorblind, the Constitution is not colorblind, there must be some amazing public interest in doing so, and you're going to have to prove that to us. Otherwise, you can consider this law dead on arrival when it's the Supreme Court. We're going to rule this thing unconstitutional. Okay, so strict scrutiny is this idea the Supreme Court, anytime they see a classification based on race, you're going to have a really tough time proving that it's not unconstitutional, based on the fact that the Constitution is supposed to be colorblind. Okay, important amendments to know. The Bill of Rights, again, I'm going to get that sheet on Canvas that summarizes the Bill of Rights for you guys. The 13th Amendment, right? More democratization, right? African Americans getting the right to vote. 14th Amendment, huge, super important. You got that, you got, first of all, the first part of it, which says if you're born in the United States, you are automatically a citizen. And then you have the Equal Protection Clause and you have the Due Process Clause of the 14th Amendment. Equal protection, again, extending civil rights. Due process, again, extending civil liberties. 15th Amendment, I totally messed up. 13th Amendment abolishes slavery. 14th I just did. 15th is where you get the more democratization. African American males get the right to vote. Sorry, I messed that up. 16th Amendment, you're going to get the fact that Congress can now tax our income. So this creates the income tax. Okay, some people say this is important because as the federal government now has more money from our income taxes, we start to expect more services from the federal government. So some people say that this is, or argue that this is led to growth of the federal government and what we expect from the federal government. 17th Amendment, more democratization. Okay, so you get the direct election of senators. 19th Amendment, more democratization, more democracy. Women are guaranteed the right to vote. 22nd Amendment, the president gets 2 terms. Okay, the 24th Amendment, this is going to eliminate the poll tax. 25th Amendment, you get the presidential succession. Okay, so this is going to spell out the president is unable to perform their duties. What happens? All right, so the Speaker of the House is third in line, and then we start getting into the President pro tempore, and then you get into the cabinet and so forth. 26th Amendment, okay, this is going to be 18-year-olds are guaranteed the right to vote. All right, so you're talking right around the Vietnam era, right? So they're being sent to war. Why are they not being able to vote in some states? This is guaranteeing you're 18 years old, you got the right to vote in your state. Okay. Okay, the court cases, Marbury versus Madison, judicial review, that you should be very familiar with that. I'm not going to get too in-depth with these, all right? Now, the court cases could show up in the concept application essay. I'm going to have a video up today as well that goes over an example of the argumentation essay and this new kind of beefed-up concept application essay. You could see the court cases show up in that, all right? I'm going to, again, get you like a one-page sheet that just sums up what is really significant about each one of these court cases. I haven't really hammered you guys on knowing the ins and outs of all these court cases because you're not taking this cold FRQ where you don't have information in front of you and your notes in front of you. And the court case, right, the Supreme Court case comparison essay is just simply not on the test. All right, but it could show up on the concept application. I'm going to get you guys a sheet that kind of sums up each one of these in a sentence. However, you do have that Quizlet that I've provided for you guys that sums it up pretty nicely. Marbury versus Madison, judicial review. McCulloch versus Maryland, right? What's significant? We're seeing the growth of the federal government relative to the states, an affirmation of the supremacy clause, and implied powers do exist, all right? A lot of you guys in that last essay, you said that states can nullify a national law. That is not the case. And that is not the case because of this case, McCulloch versus Maryland, okay? USA versus Lopez, you're seeing growth of the states relative to the federal government, right? They're ruling that federal law unconstitutional. That Gun-Free School Zones Act does not, it cannot rest on the Commerce Clause. It's an overstep of the Commerce Clause. Okay, Baker versus Carr, right? Where you at? You're in Tennessee. What's going on? Tennessee is not redrawn their district lines. They've ruled that a violation of the Equal Protection Clause of the 14th Amendment. It starts to set up this idea of one person, one vote, that districts should be as equal as possible. And the court as well has said, normally we stayed out of these particular cases, but this is an Equal Protection Clause issue. So going forward, we can rule on these cases. Shaw versus Reno, right? This is North Carolina. That's the Equal Protection Clause of the 14th Amendment as well. Racial gerrymandering violates the Equal Protection Clause of the 14th Amendment. Remember, North Carolina had created this majority-minority district, and what they're saying is that you cannot racially gerrymander. Okay, it can't be the sole reason you're doing that. Wisconsin versus Yoder, right? This rests on that free exercise clause of the First Amendment. All right. So, and really the question is, when does somebody's free exercise clause. Those free exercise clause, First Amendment rights outweigh a state's education interests. And then in this particular scenario, they're saying that the Amish interest outweighs the state's educational interest. A couple of reasons why. These Amish kids were already about 13 years of age. Therefore, they've already received a lot of public education. Second thing is just the peaceful nature of the Amish as well. So what you're seeing an affirmation of the free exercise clause in Wisconsin versus Yoder. Schenck versus United States, I kind of already touched on that, as well as Engel versus Vitale. New York Times versus United States, the key thing to get from this is that the government cannot restrain information that the media has. So if the media is privy to information, even if it's something that is particularly sensitive, they can publish it. The government can't stop them from doing it. Basically, you get out of this court case that the media, that free press is absolute. Okay, the freedom of the press is absolute. Tinker v. Des Moines, students basically don't give up their First Amendment free speech, symbolic speech rights as they enter school, as long as they do not negatively impact the learning of others. Okay, so you could not come into school and have something particularly provocative that is going to disrupt the learning environment. However, if you come into school just simply wearing a black armband to protest a war or something like that, that is perfectly legal under Tinker v. Des Moines. All right, Gideon versus Wainwright, Sixth Amendment right to counsel gets extended to the states. So states have to provide that legal counsel to you if you cannot afford it for major state crimes. McDonald versus Chicago. Chicago basically had banned handguns. Does the Second Amendment apply to the states? Can Chicago do this? And the Supreme Court says no, they can't. That Second Amendment is part of that liberty, as part of the due process clause. So you're seeing the Second Amendment, and you're getting the 14th Amendment's due process clause in there. That's selective incorporation. Gideon versus Wainwright, selective incorporation as well. Brown versus Board of Education is, does school segregation violate that equal protection clause of the 14th Amendment? It's a unanimous decision. They all say yes. It was a 9-0 Supreme Court decision. Yes, school segregation violates that 14th Amendment equal protection clause. Roe v. Wade, right to privacy. Okay, it does. In a previous court case, which is not required, which was called Griswold versus Connecticut, they ruled that yes, a right to privacy does exist. And then in Roe v. Wade, they say this right to privacy extends to women and their reproductive rights. Okay, notice with all those court cases, I can tell you what parts of the Constitution are at play. That is probably, I think, the most important thing for this exam you guys take Monday, is that you can, off the top of your head, say to yourself, McDonald versus Chicago is Second Amendment in 14, Tinker v. Des Moines is First Amendment free speech, New York Times is First Amendment freedom of the press, Engel versus Vitale is First Amendment establishment clause, right? If you can do that, that is going to help you out. I'm telling you, you cannot go back and teach yourself this stuff in a 15-minute time span and expect to do well on this thing, okay? For the Declaration of Independence, I just want you to go see my Quizlet, right? I've got that set up for you. I would jot down what I have written down there. Look at your notes. Articles of Confederation as well. Those key weaknesses. We've been over and over this stuff. The Constitution as well. I want you to go see. I'm going to provide this document for you guys on Canvas that's going to set that up for you. Fed 10, right? What is he arguing for in Fed 10? He's arguing for basically pluralist theory, allow groups to compete. There's going to be these factions, let them compete. We don't want participatory democracy. You're going to get this dominant majority that infringes on the rights of the minority. We want a representative republic, all right? We want federalism as well to dilute power. These groups are going to compete, and it's going to prevent this one dominant majority, okay? So he's really arguing for pluralism there. Brutus 1, right? It's the anti-federalists. They're against the Constitution. They want more participatory democracy. Sorry, my dog's barking. Fed 51, separate your powers. Let each branch check the others, all right? Fed 78, we want an independent judiciary. They will then be able to protect the Constitution. We don't want the judiciary to be... we want them insulated from public opinion. We don't want them elected. We want them serving life terms, because then they're going to be loyal to the Constitution and not to us, and not to what is popular with the people. Fed 70, we want one president that has this energy. Okay, so we want this one president that can act quickly. We want basically a powerful presidency that is one person. Letter from a Birmingham jail. There's a lot in here, okay? I want you to go rewatch that video I put on Letter of Birmingham jail, and I want you to take a look at the Quizlet cards that I have up on Letter from a Birmingham jail. Jot all that stuff down. Make sure you're familiar with that, okay? All right, that wraps it up.